following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the intricacies of the laws governing trusts in Sri Lanka. How does Sri Lanka recognize trusts in its legal framework? And is the doctrine on par with modern standards? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we discuss key legal concepts and break it down for the layman. Tonight we have a topic, I believe it's a follow-up almost of our previous episode which we did on last wills as well, and that is on trusts. Now, trusts, of course, we use the word trust on our day-to-day language, and essentially in a legal concept as well, there's a little bit of a similarity, but of course there's a lot more intricacy when it comes to actually bequeathing assets and keeping assets and estate planning. Well, it's quite a complicated topic, but we have someone that I believe would be able to best explain this discussion, and he's not a new face on the show. To speak about this topic, we have with us Attorney at Law Udara Soysa. Thank you very much once again, sir, for taking the time to explain yet another key legal concept. Of course, not a new face on the show. A small introduction on our guest. Mr. Udara Soysa is an attorney at law, a published author, and a senior law lecturer and lecturer in charge for international law for postgraduate programs at the Bandaranaike Center for International Studies at BMICH. And if you've watched any of our previous programs with Mr. Soysa, you would know that we're in good hands when it comes to this topic. Well, before we go into the discussion, here's a small breakdown of how we're going to approach this topic. So first, of course, we'll be touching the fundamentals, the basics of trust. What is a trust and where is the legislature that's responsible for governing trusts? Next, we'll be talking, of course, about the application of trusts in different contexts and the current context as well. And finally, we'll be talking about reforms and the future of trusts in Sri Lanka.
Hello. My name is Brahmada and I'm a student. So my question is on the fundamentals of trust. So how are trusts formed in the legal framework of Sri Lanka?
All right, well, without any further ado, let's get right into the discussion. Well, sir, we have quite a lot to break down when it comes to this topic, especially considering just how vast the area is and just how much it affects people that are involved as well when it comes to different types of trust in the different contexts. But before we get into any of that, let's of course get down to the basics. Could you explain to us in Sri Lanka's legal framework, how are trusts defined and how are they recognized? What's the legislature?
Perfect. So, before we go to Sri Lankan law, we must understand that trust is a creation of English law, right? So it's actually one of the most innovative, right? Trust is one of the most innovative creation of English law, and often it is not the Roman Dutch law. Indeed, actually, in totally, it is not the Roman Dutch principles, but English legal principles that applies to trust. Now, though this is a creation of English law, that doesn't mean in Sri Lanka that we can actually use the entire gamut of English case law or English statutes when it comes to trust in Sri Lanka. So we learnt as law practitioners, whenever there is a legislation in Sri Lanka, we are always limited to the four corners of that legislation. So in the context of Sri Lanka, right, though it's inspired and formulated based on these English principles, the four corners of trust law in Sri Lanka are limited to the Trust Ordinance of 1917. Right? However, one must understand that it is best for anybody understanding trust to have a general understanding of English law of trust, but most of these classic English law trust doctrines are codified right here in the Trust Ordinance. Right? So when it comes to looking at what is a trust, right? So again, as I said, we have to look at the Trust Ordinance. So if you look at the section 3, which has defined various parts of trust, there's a very technical definition that you can look at in Section 3 of the Trust Ordinance. So let me simplify it for a normal person to understand. A trust is a legal relationship. Right? A trust is a scenario in which let's say I imagine that I indeed have a son, right, who is 1.5 years old. Am I able to give him my car? Suppose that I'm dying next week of a terminal sickness. Am I able to give him my car? Am I able to give him any jewelries, right, my watch? No, he's so small, right? So what I can devise is, I can use you, quite a trustworthy person, I can give the property to you to hold it on behalf of my son. So it is a legal relationship in which a person, meaning a trustee, holds rights on behalf of another person who we call as the beneficiary. So who am I? I am, in English law, I am called the settler, but in our legislative framework, I am called as the author of the trust. So here, author of the trust is a person who, right, who repose and declare confidence. In simple words, the one who creates this trust through a trust instrument is the author of the trust, where the person who keeps the property on behalf of the other person would be the trustee, the ultimate beneficiary of the trust instrument, or the trust declaration is called as the beneficiary. So usually there are 2 or 3 people exists within the formulation, declaration of a trust. So in simple, trust is a legal relationship in which a person holds rights for another person. But if you want to go a bit more technical, you can look at the trust ordinance, which says trust is an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner or declared and accepted by him for the beneficiary of another person or of another person and the owner of such a character, while the ownership is nominally vested in the owner, the rights to the beneficial enjoyment of the property is vested, the beneficiary vested in such other persons or in such other persons concurrent with them. That means basically I transfer the legal title to you. So you, under your name, the legal title is there, despite that another person will have the beneficial title. So property is kept for a person other than yourself, though the legal title is with you.
Right. So basically you are holding, someone will be holding on to a certain property that is declared by a certain individual, the author of the trust, in order to bequeath it on to a beneficiary. And so just a question of curiosity, does that mean trusts are most usually formed when the beneficiary is incapable of forming their own contract, or is it not always the case? Is there a very common genre of where we see trusts occur, or is it completely across a different spectrum?
It has a wide spectrum, right? Now, for example, often it could be done to benefit a beneficiary who may not have his own individual right, the capacity to hold it. As I said, a child who is 5 years old to 1 year old, right? Anybody less than 18, or a person. Recently, I've done a trust for a child who is not a child, adult who is autistic, right? So a person who does not have the capacity, or sometimes you may not feel confident enough to give a gift to another person. Perhaps he spends a lot, he's a spender, he might spend a lot. So what you could do is, rather than giving this tens of millions of rupees to this person, you could declare a trust and give the property and make sure somebody who's responsible, somebody that can be trusted, holds these rights for the beneficiary. Now, we will discuss later in terms of religious trusts and charities as well. So this could even be for religious and charitable purposes. And often certain injustice situations can also lead to trust. For For example, now imagine some people are trying to kill me and I have to run from the studio so fast. I give my watch and all my belongings. I can't run with all this, right? So I give it to you and I run away. So I have given you the legal title. But can you or not keep this for you? Indeed not, right? So in this situation, sometimes I might not declare this in a trust, but I might just give it to you, right? But the circumstances has resulted in this, so this could be something called implied trust, right? Or rather a constructive trust where the courts construct the trust under circumstances. So remember, trusts are not only expressly declared by the author, but could create through operation of law as well, right? So as I said, as you also asked, trust is one of the most complicated, complex and very broad range topic and can create for a multiplicity plethora of reasons. Often can create for somebody who doesn't have the capacity, or sometimes you could create it for a religious purpose where you want the trust to go on forever, right? And sometimes the courts will create this to avoid certain injustice where a person is given property and you cannot in good conscience hold it for yourself. Right? So indeed there could be various, numerous, plentiful reasons why a trust is created.
Right. So there is a plethora of situations in which a trust can arise. I think that begs the question, what about the validity of a trust, sir? How exactly, what are the key features of identifying a valid trust, and what are those requirements?
I think this is the question of the day. Right? So if you look at the classic English case of knight versus knight in, right, long time back, right, in 1800s, in House of Lord Langdale, has given this basic three certainties, which is also codified in our law as well. So when it comes to express trust, remember we have to understand trust in terms of whether it's express trust or a implied trust, right? So express trusts are created by declaration and implied trust are creation of operation of law or creation of law or a legal fiction. Now I think your question is about express trust. I, Udara Soysa, would like to make a trust, right? Let's say for a person named X, where you would be the trustee. So there are these three certainties I must always keep in my mind as I am the author of this trust. So what are these three key requirements? The intention, subject matter and the objects are the key requirements for a valid express trust. Suppose one of these fails, this would not lead to a trust being arisen. Sometimes this could lead to it being a gift, or it could be something else, right? Now I will go one by one with each as you ask about these requirements. Now I have given you something to your hand. The question is whether I actually had the intention to create a trust, or I actually wanted you to enjoy this outright. The language of the trust instrument or language that is used by the author or the supposed donor is important. The question for the courts is whether this was given to you in full confidence in terms of some kind of a moral obligation to hold it for somebody else, or whether it is a legal agreement, right? A legal agreement between myself as the author and you as the trustee. That is the $1,000 question. So the courts will look at the language that is used in the trust instrument. So certain words where, for example, if I have given some money to you with a mere hope or in full confidence with certain precatory words to hold it for somebody else, then in this situation it might not constitute a trust.
Unfortunately, I'm going to have to interrupt you there as well, sir, because we have come to term in this segment, but that's an extremely important question that we have to delve into. Before we discuss that, how about we go in for a short commercial break? You're watching Law Land and Liberty.
Nishad Wickramasinghe and I'm a student. My question is on current context, what forms of trust apply and in which circumstances does each apply?
Welcome back to Law, Land and Liberty. We are in conversation with attorney at law Udara Soysa, and we'll talk about trusts and the legal framework surrounding trusts. Now, sir, we just left off on what I believe what you mentioned was the question of the day when it comes to the valid creation of trusts, and we were speaking about the certainties that are surrounding the creation of a valid trust. Could you please continue to elaborate on that, sir, on exactly how a valid trust is formed? We were just speaking about intention. Could you please explain further to our audience, sir, when it comes to intention, how it's different from enjoying outright and, of course, keeping as a trust?
Indeed. For example, if I can use certain imperative, very clear-cut words, for example, Anuradhi, please hold this on trust for my son, or hold for persons A, B, C. In this situation, the words are very strong, very clear, very imperative. There's no doubt that you are not to enjoy this outright. In this situation, you will be more of a trustee. But suppose that I have given you my property and saying, look, Anuradhi, hold this on for my son if you like to hold it or given that hope. Right? This mere hope will not create a trust. So in fact, you can hold it for yourself, right? Not for anybody else. That means, of course, this is a gift from Udara to Anuradhi. So this is why I always tell the clients that you really need to understand when you create a trust, the words must reflect your intention. It is not what is in your heart necessarily, it is what is manifested in the trust instrument. That is objectively and reasonably understood. You must, with a reasonable certainty, manifest your intention in the trust instrument. Secondly, the subject matter has to be clear. The corpus, the subject matter of the trust has to be clear. If suppose I have 10 wine bottles, I am not, as per the trust ordinance, I am not able to make a trust with 5 wine bottles. Why? You do not know out of these 10 wine bottles, out of these 10, which 5 is yours. There's evidential uncertainty. Or suppose I take all my money and I say, I make this trust with bulk of the money. Anuradhi, do you have any idea what this bulk is about? Or I have a lot of valuable vehicles or let's say stamps or whatever the collection. I say, let's take the most valuable of this and make a trust. The key point here is whether there is an agreement between the trustee and the author of the trust, in which with reasonable certainty the trust property can be identified by the trustee. So this is as very technical. Now, when it comes to the corpus, if you are unable, if you the trustee are unable to understand the corpus, you will fail in your duties as the trustees. So it is unfair for the author of the trust to hold this so-called equitable duty upon the trustee. As you will later realize, this is based on law of equity. It is not fair for you to be given equitable obligation to hold it for somebody else, a property that you don't even, where you don't even know what it is, and and you are unable to reasonably ascertain within the four corners of the trust instrument. Finally, the objects, right? We spoke about intention and subject matter. Now finally we discuss about the objects of the trust. Objects of the trust means, in short, you can look at us in terms of beneficiaries. What is the purpose of this trust? Why was this created? To whom benefit was it created? Right? For example, now the earlier trust that I declared for my son or to a person named X, we know that this is for the benefit of my son. Or you know that this is for the benefit of the person X. Right? When it comes to discretionary trust, you can in fact make it for a class of people. But again, the point is whether this class of people can be reasonably ascertained, whether reasonably identified. You cannot put any unreasonable equitable obligations on the shoulders of a trustee and expect him to carry out these duties. Of course, if you are unable to give reasonably certain instructions to create a trust as the author of the trust, then you cannot expect the trustee to be reasonably enforcing and ensuring, protecting this trust. So in these situations, the law will not recognize such reality, such phenomena as a trust. So summing up, the three most important requirements for a trust is certainty of intention, as we spoke in the last segment, certainty of subject matter, and certainty of objects. This is what every author of a trust in Sri Lanka must keep in their mind when making a trust.
Right, so there are specific roles where there are specific features that must be clearly defined in order to not put any additional burden on the shoulders of a trustee who is holding on to this trust. I think that is a good segue for us to get to the next question that we have now. We spoke about how the author of the trust is not supposed to be putting any equitable burden on the trustee, but what exactly are the roles and responsibilities of a trustee in Sri Lankan trust law, sir?
Perfect. So now, earlier I was the outright owner, suppose, of the car. Now I will transfer the title of this car to you, Anuradhi, the trustee. So now, prior enforcing any or imposing any duties on you, it must be understood the legal title must be vested on the trustee. So that means, in fact, myself, Udara, as the author, needs to transfer the legal title to the trustee. Now you have a legal title of property. Now this is where the situation now becomes a bit interesting. Now you, in your hand, under your name, under your account, you have this money or property, land, whatever. Now this is under your legal name. Right? Now the trust ordinance in Sri Lanka has given 20 odd duties. Right? So primarily being the fiduciary duty, but there are so many other duties that we will discuss in a bit. But what you must remember is, although you may be eligible for a compensation or a remuneration, right, or certain level of indemnity or reimbursement, you are not able to enjoy this property for your benefit. I have transferred my car to you on trust for my son. So you cannot use this to run pick me and Uber hires to benefit yourself. However, it could be used in a manner that it could be objectively benefit my son. So your primary duty is you are a fiduciary. That means you have a fiduciary responsibility for the beneficiary who has the equitable title. Remember, your legal title, though you are given the legal title, right, as per trust ordinance, your legal title is almost handcuffed, chained by the equitable title of the beneficiary. So your primary fiduciary duties are there. Then you have to obviously avoid conflict of interest. You have a loyalty to the beneficiary. You have to ensure that you account. You have to have competencies. Right? You cannot, if you sometimes you might have to invest this money. Right? You must do, of course, your duties are partly in the trust ordinance. You can, as I told you, you have around 20 odd duties, and if we are going to discuss that, I think that will be the end of this. We can discuss for 2-3 days, right? But short and sweet, I have listed out the primary duties. Furthermore, certain additional duties can be listed in the trust instrument. That means a trust deed, right? In which author may have given you certain additional duties as well. And suppose you have gone beyond these duties and you have used this money for your betterment or for your children's betterment without focusing on the beneficiary, you are in breach of trust, which is right, you are in a civil breach of trust, and you may have to compensate, and will often be the case, for whatever you have taken from this trust. And this is a serious situation that a trustee should always avoid, because you are given a very high position to hold a property that is of somebody else's under your name for that person. So you are held to a very high standard. As a trustee, you are held to a very high standard. You cannot play the fool with this trust property. Your primary duty, it is to benefit the beneficiary, not yourself. Indeed, that doesn't mean you may not be given any reimbursement for whatever. Let's say you have to do some repair for this vehicle, or you have to go here and there to manage this or to invest. Of course, we are not selfless people who have attained nirvana or enlightenment. We are human beings who behave on our benefits, right? Yet that reimbursement or any other salary remuneration aside, which would be given in the trust instrument, you must not benefit this property for your own sake. In fact, your loyalty is not for yourself but to the beneficiary under all circumstances. So this has to be done very carefully by the trustee to ensure that you do not breach the trust. It's a civil wrong that you must try to avoid.
Right. So moving on, there's a small question of curiosity that arose when mentioning exactly what duties are owed by the trustee to the beneficiary and what responsibilities and the standard they are held in. Considering trustees, and then there are asset managers, professional managers for assets. When considering in a layman's point of view, how exactly is it advantageous? Is it by any chance advantageous to have a trustee maintain your assets in comparison to a professional manager that you would hire? Of course, the legal title would not be transferred, I believe, when it comes to that instance. What exactly is your take on that? Is it more advantageous for us to have a trustee rather than a professional manager for our assets?
Depends. Now, let's not have a very short-sighted view on who's a trustee. Trustee could be one person or a group of people or now a company as well. Right? So that could be, so you can have a natural person or persons or a legal person, meaning a corporate body. Right? So in certain circumstances, for example, as I said, we go to our first discussion on what is the situation. Right? Imagine that we have a situation of a child who is autistic. Right? And in this kind of circumstances, it might not be actually viable to have this autistic child to deal with a advisor or a consultant, right? In these circumstances, very sensitive, you might have to approach a trustee to manage the property on behalf of him, somebody who can be given the utmost trust in this regard, right? However, there could be certain very simple situations where you don't have to go deep to establish a trust, but rather you can have a property manager, asset manager to manage. But remember, it is erroneous to believe that trust is just one person who you trust, you give it to the person to hold the obligations on behalf of somebody else. No, right? You could have, often people ensure that they have several trustees. You can have several trustees to maintain property. Or if you want to make it a bit more modern in today's commercial and corporate context, you could in fact have a corporate body, company, incorporate under the Companies Act. So all of that is available and potential and possible. So what is important is you look at the facts of the situation, right? You look at the facts of the situation, and based on the facts you realize that what kind of a mechanism is most suited to help the client or help the beneficiary. Certain situations, I think trust would not be actually advisable. For example, some short-term reality, you make a trust, then now you have transferred the property, the title to somebody else, and now we have a bit of a complex situation where these complexities could have been easily avoided by just getting somebody to manage it without in fact transferring the legal title, right? But ultimately you need to understand most realities of laws are facts-based. Every scenario you must look at its own merits, on facts, and decide as a legal practitioner what to do and what is the best advice you could give your client in that given scenario. Sometimes small events, small scenario differences can totally change whether we need to resort to a trust under the trust ordinance, or you could just have somebody advising him to take care of the property under.
Yes, of course. There's always different circumstances, and relating to the different circumstances, we can of course approach the trust doctrine or other alternative pathways. But it's of course important for us to understand the fundamentals of trust in order to even consider different alternatives or different opportunities for us to protect our assets and to bequeath our assets. Well, we are now coming to the end of this segment as well. Stay tuned as we speak about the final bits, maybe the reforms, and of course speaking a little bit more about the distribution of trust property as well. Stay with us. We're Law, Land and Liberty. Be right back.
Hi, I'm Tinri, and my question is on reforms and the future. Is the doctrine of trust adequately updated for modern context?
Welcome back to Law, Land and Liberty. We are in our final segment and we are in conversation with attorney at law Udara Soysa. We were talking about trusts, and we just finished a segment that I believe would have clarified a lot of doubts in laymen's minds regarding the creation of a trust and how valid trusts are created, as well as if there is even a necessity for trust in certain circumstances and certain instances. So I believe in the first segment you mentioned religious trusts and charities as well. Could you please explain to us about that specific area of trust? I believe it's a completely intricate aspect. It's not as straightforward as an express trust would be. Could you please explain to us?
Yes. So if you look at the section 99 of the trust ordinance has given certain provisions for a persons, right, to establish a religious trust. So section 99. So section 99 gives again these four categorizations are based on an English law case called PEMCEL, right? PEMCEL versus Inland Tax Commission in UK. So if you want to make a trust for a charitable purpose, right, there are three predominant heads. For example, relief of poverty, for the furtherance of education, right? I'm actually talking about charities in general, then we will come to religious purposes as well, right? For religious purposes, and then for any other purposes that in fact go in line with charitable nature, right? So, and actually you need to understand that in UK law now it is 13 heads under the latest Charities Act of 2011, right? So now remember, these UK laws are not directly applicable to us, and as we are limited and unfortunately restricted to the four corners of the trust ordinance. So for example, if you are thinking, right, of establishing a religious charity, the advantage is that you do not have to specify your objects, the beneficiaries, in a very clear term. Now you know when it comes to any express trust, you need to either have a list of your beneficiaries, or if it's a discretionary trust, you have to have a closed class of people. Suppose you want to have a religious trust, right, charitable trust, where you establish this religious charitable trust to benefit all the Buddhist devotees in Kandyan province, you are able to do so. Where you might not be able to do that in a normal express trust setting, because then it will fail for the certainty of objects, the three requirements. So the advantage of in fact having a religious or generally charitable trust is that it allows a little bit of freedom when it comes to the normal trust formalities, because you know that the societies need these charities to function. But do not think that to make a charity you must have a charitable trust. No, you could have a corporate body doing certain charitable work, right? Not all the charitable organizations are trust, right? So remember, you don't have to have a charitable trust to do charity. You could have a NGO, etc., to do your charitable work, or you could create, even within that NGO, you could create a trust, right? So there are certain benefits, as I told you, right? In several other countries, there are so many other beneficiaries, right? Tax beneficiaries. This is a very large area of law that I think we should.
That's a discussion.
Yes, indeed, we should develop. This is 1917 legal framework, but it is advantageous in many ways. It offers a level of flexibility when it comes to normal express trust, but do not make the mistake thinking that you have to have a trust to do charities, but often a lot of charities are
trust based. Right. So that is the very absolute basics.
And for example, I can add one last point now. For example, normally a trust would exist for the lifetime of a person, right? Because there's a rule against perpetuities in trust. For example, if I make a trust for you at the end of your life cycle, then this trust would not be existing after that. But the exception for that is again what? Charities. Right? Charitable trusts could in fact go on avoiding the rule against perpetuities. Perpetuities means in general terms, you do not want a trust to go on forever, because once you have a trust to go on forever, you are putting a infinite, perpetual, equitable obligation on a trustee, which is not very fair, which is not in fact administratively possible even, right? But when it comes to for the charitable trust doing these charitable purposes to help people, to uplift people in these circumstances, you are given this certain leeway through the law to function. So of course there are actually many advantages of charities, charitable trust.
And I'm sure a lot of us would have already recognized that we know multiple famous charities done by renowned people from the past that still exist. So when mentioned that a trust can only exist for the duration of one's lifetime, this is the exception to such a condition that has been imposed in order for charitable acts to be promoted and of course for it to be facilitated. Now sir, moving on from that topic, I believe not a lot of us have charities, or not a lot of us have a lot of influence when it comes to that aspect, but when it comes to last wills and when it comes to bequeathing of assets posthumously, which we just spoke about in the previous episode as well, could you explain to us, trusts I believe play a very specific part in that role of bequeathing of assets through last wills. Could you please elaborate on that aspect, sir?
Yes, so I could make a trust inter vivos, that means while I'm living, right? Or I could make a testamentary trust through my will. So this is one of the exceptions where I don't have to transfer the legal title. Right now, for example, if I am to make a inter vivos express trust while I'm living to you, through you to my son, I have to transfer my legal property to you, right, for my son. Now, for example, if you are going to make a testamentary trust, for example, you know that the legal title in a situation of a will is only transferred after my death. So practically, sometimes what people do is they would make a nominal trust situation where before my death I would make a nominal trust, and let's say if I have like 100 million, I would make it for like 1 million, right, for my son through you, and the rest of the bulk of the property, bulk of the estate might come through the last will. In the last will I might remove the legal title, right, from my estate, right, through you to my son. Now, the advantage situation is that indeed, again, let's say if I am not living, right, for a long time, and I am also not sure like when to give it. So I imagine that I don't know exactly the time of my death, right, and I want to benefit a person after my death. It is advisable in this situation that nominally I make a nominal trust situation where yet the bulk of the estate now comes through my will. We use the word testamentary. Testamentary is where the succession happens with, right, through a will. So the legal title will move to you. Then you, within the trust instrument, must, now the trust instrument now can even be the will in this situation, right? Now this could be a testamentary trust. Now in that you keep it for the beneficiary. But remember, key is that though you got the bulk of the money after the will, but imagine that I have created this even before my death, for example, the nominal trust. You are now existing as a trustee even from before my death. You will function to be the trustee. So your trust duties now will almost precede my death. So while I am alive, you become the trustee, but now after my death, you get every inch of my property that to be held, the bulk of the property, and then you will function. Now this can be used often to benefit our offspring, right, or any other purposes that we hope to. And some people have made certain testamentary trusts in a situation to benefit certain schools, right. I think you know, many famous people who are willing to give their, you know, houses, etc., to the schools, right? So ultimately, you could do this. Like imagine that you want to live in your house till you die, and later you want this house to go to your son or to a school of your choice. Then you could do that through a trust as well. I mean, again, you could give it outright as well, but the purpose of actually giving a trust is you, through your trust instrument, regain a level of control on how and what, why, when this property is used. Even after your death, you keep a level of control, because if you give outright as a testamentary gift, now what will happen is, in that situation is just a disposition where that person can just do whatever they want. But if you have a trust, then you fix this into the trust, and the person is stuck within the four corners of this trust.
So they are obligated to carry out their duty posthumously or inter vivos.
Yes.
So then there is a bit of a safety net as well when it comes to that. So bequeathing assets via trusts, in-laws wills, we just spoke about it as well. Well, finally, sir, we're running out of time, but I believe this is the one of the most important questions. According to you, sir, do you see any adequate reforms, or is there any modes of improvement of the current doctrine? What are your thoughts, sir?
Superb question. Now, our trust ordinance is over 100 years old, though it has been reformed, right, over the years. This is a 1917 document. The base is in 1970s, and you know, there's nothing, right, that exists without change, and especially from as far as 1917, things have to change, right? And now we see trusts are often used in commercial and corporate contexts. Now we have a very updated Companies Act 2007. Now compare the time, right? This is 1917 to 2007. So you see almost 100 years of a gap between two legislations, right? So now, in my view, if you look at other countries, right, they have not only developed the entire trust framework, but they have developed sub-segments of trust, such as charitable trust. In UK, 2006 Charities Act, 2011 Charities Act, and US as well. Almost all the legally developed countries have ensured that they have codified mechanisms to make sure something as complex as trust is not left to the hands of a document that is centuries old, and also not to, right, give a high level of uncertainty and lack of clarity. So I think comparing our trust legislation, which is again updated over the years, but I think ultimately to fit in with that modern commercial and corporate frameworks, it is best that it is updated, totally redone with a new piece of legislation that would actually benefit people, because this trust is not a concept that people can easily identify. And I, of course, always advise anybody who would like to make a trust, get a legal support to do the trust, right? Otherwise, even one or two words,
Numerous loopholes through which it can fall.
for sure. Now, one or two small mistakes in the drafting of the trust instrument could result in this failing. So be very careful. And again, it is advisable that the legislators, drafters, that they develop a new legal framework also to make sure it is a bit more easier for people to understand, manage trust.
Right. Well, I believe that is the perfect note for us to, unfortunately, end our discussion on. Time has come against us once again, despite having quite a lot to discuss, a lot more to discuss, considering the vast nature of trusts as well. But unfortunately, our time with you here today, sir, ends right now. Thank you very much for taking the time to enlighten our audience regarding this very complicated topic. Thanks again, sir.
Welcome, Anuradhi.
All right, well, trusts are a concept that is not new to many of us, but being knowledgeable about the legal basics allows us to be wary and protect ourselves from any inconsistencies that may potentially amplify into drastic results. We leave you tonight with the words of Lincoln Shafi, who is a former United States Senator. Trusts are built with consistency. That is all we have for you on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube channel, youtube.com/Other Derana English. Thank you for watching. Have a great night.